right, Mr. McWilliams?
Your Honor, at this time, the defense rests.
Okay. All right. Any rebuttal by the people?
No, Your Honor.
All right. Members of the jury, all of the evidence for you to consider in reaching your decision has been presented to you. What remains now is for you to hear the closing arguments of the attorneys and my instructions on the law. I'm going to remind you that the closing arguments, like the opening statements, are not evidence. The closing arguments are the opportunity presented to the attorneys to summarize the evidence as they see it, and to present their legal theories to you. You, as the deciders of the facts in this case, will base your decision on the evidence that has been admitted and received in this case and the law as I give it to you. Now let me explain to you that in the closing arguments and how that's going to work. First, you'll hear the closing arguments of the prosecutor. And when the prosecutor, Mr. Moran, has finished his closing argument, Mr. McWilliams will have the opportunity to give you his closing argument. When Mr. McWilliams is finished, Mr. Moran will have a second opportunity to speak to you in what's known as the rebuttal portion of closing. The reason that the prosecutor has provided two opportunities to speak to you and the defense is given one is that it's the prosecution that has the burden of proving the case beyond a reasonable doubt. Now I want you to know that the attorneys are going to do their very best to recall and summarize the evidence as best they can. If, however, during the course of the closing argument, your recollection of the evidence differs from their recollection, go with what you remember. All right? All right, Mr. Moran, whenever you're ready.
Thank you, Your Honor. Good morning, ladies and gentlemen.
Good morning.
I want to reiterate something that Judge Kenny said from the very beginning about recollection of evidence. And I always tell jurors before closing argument that it's important that you understand that when we talk about what we think the evidence means, we're talking about our recollection of the witness's testimony or the exhibits. We may be mistaken about a minor point. And I'll give you an example. In opening statements, you may recall, I talked about fingerprints that were recovered from the jewelry store, and I think I said that the fingerprints were recovered from the glass counter, from the defendant that put his hand on the counter, jumped over the counter, chasing after the store owner. And I was mistaken. There were fingerprints there, but they weren't raised. The fingerprints that tied the defendant to that crime came from that layaway envelope. So that's an example of something that I might be mistaken. So if I say something that's different than your recollection, I would ask you to go with your recollection. If I say the witness said there was green socks or blue socks, and your recollection was they were yellow, then go with your recollection. Please know I'm not trying to mislead you. I may just be mistaken about a fact or circumstance about the case, but it's not my attempt to mislead you in any way, shape, or form. Fair enough? This is closing arguments. And as Judge Kenny indicated to you, it's our chance to tell you what we think the evidence means and how we think the evidence fits to the elements of the crime. And you'll recall that my burden of proof is beyond a reasonable doubt, to prove the elements of the crime beyond a reasonable doubt. So we'll talk about those, we'll talk about the facts, and I'll ask you to keep an open mind during the course of our closing arguments. And when we're done, I get a chance to speak to you one last time, briefly in rebuttal, to answer some of the things that Mr. McWilliams may bring up. And that's because I have the burden of proof. And as I said to you in the opening statement, the burden never shifts. It always stays on this side of the table. Always here, never there. They don't have to do anything. They don't have to prove anything, say anything. They can do crossword puzzles all day long if they want to. But they don't have to do anything. It's my job. But if they do produce evidence, which they did in this case, it's your job to weigh that evidence by the same standards you would use to judge the credibility of the witnesses that I produced. So I'm going to ask you to do that. I'm going to ask you, when we talk about credibility, I'm going to ask you to judge my witnesses by the same standards that you judge the defense witnesses by. The same rules, the same standards, the same questions. Those are the questions I want you to ask. Fair enough? Okay. For 6 months last year, the defendant and his gang threatened and terrorized Northwest Detroit. They had a plan to rob people in their own homes, to rob businesses, to rob people on the street, to make money. You've heard testimony from 2 of the co-conspirators, Mr. Adams and Mr. Williams, who talked about how this plan evolved, how it unfolded. And they told you that it evolved and unfolded when the defendant got out of prison in January or December of 2014 or 15 of January 15th. And his plan was, instead of getting a job and making money, his plan was to rob people. And not like he had done before by breaking into homes, because that was dangerous. Mr. Williams and Mr. Adams told you both it was his idea to do these quote-unquote walk-in robberies. And so that's what brings us here today. It brings us here today because we are starting with this case. And we're talking about what happened on March 5th of 2015 at the corner of Oak Drive and Clarita Street in the city of Detroit. And you've heard testimony about what happened there, how it unfolded, and how Terrence Berg, who was a federal district court judge, was shot on his porch during the course of a robbery. And we'll talk about that more. And you've heard the testimony about what happened and how he was injured and the circumstances about how that led up to them being on the front porch, to the defendant standing right by Judge Berg pulling the trigger. You've heard that testimony, and we're going to talk about it in detail in a few moments. But when you're thinking about the crime that occurred back on March 5th, I want you to think about the words that were spoken by the defendant when Judge Berg refused to let him go inside his house. The words that he spoke was, "We got a gun. We got a gun." Why is that important? Because you'll recall that the defendant is the one who was standing next to Judge Berg, standing right on the front porch, 2 to 3 feet away from him, when Judge Berg said no 3 times. The defendant is the one that said, "We got a gun." Not, "I have a gun, we got a gun." Why is that important? Because at that time, standing just a few feet away from him is his co-conspirator, is Mr. Williams. And a few more feet down the street are the other individuals involved in the conspiracy, Mr. Don Diego Adams and Mr. Timothy Russell, who were in the getaway car, who were waiting for either the robbery to go bad or the robbery to go well from their perspective, so they can go inside the house and commit the robberies, just like they did on Hilldale, just like they did on Mansfield, just like they did time and time and time again. But when the defendant says, "We got a gun," what he's really talking about is the whole concept of how they're acting in concert together, how they're acting as one unit, how they're acting as a plan to commit these robberies. We got a gun. Not I got a gun, we've got a gun. It's very important because those are his words. Those are his words. So let's talk about what he says when he says, "We've got a gun." Not only did he have a gun, he had 2 guns. And you've heard testimony about those 2 guns. One is that .40 caliber with a laser pointer. The other is a 9mm high point, which is here, found in the bag. And you can look at those guns if you want. You can ask to see them. It's clear that one is a Smith & Wesson .40 caliber with a laser pointer, and one is a 9mm high point gun. Those are the 2 guns that he says he had. So "we got a gun" is part of the conspiracy, part of the statements that he made. And the conspiracy started, as I said, in January. And you've heard testimony about that. I'm not going to go belabor it. But we all heard the testimony about how, when he got back in town, how he was the one who came up with the ideas. And that's what Mr. Adams told you and Mr. Williams told you, that it was the defendant's idea to do these walk-in robberies. His idea. So we've heard about the planning phase of the crime. And I want to talk to you about how it is that the defendant started planning the phase of the crime. And let's talk about that a little bit. When he gets out of prison, what does he do? Well, he buys a gun. He told you on the stand that he bought a .40 caliber handgun. A .40 caliber. He told you on the stand also that he didn't want to go back to prison because he just got out of prison. But then he buys a gun, which he can't have. He's a felon. And there's a stipulation that he's a felon and he's not allowed to have a handgun. So what does he do? He goes out and buys a handgun. A .40 caliber, semi-automatic firearm, and gets a laser pointer for it. A laser pointer. And he wants you to believe that he just leaves it laying around his house, he's casual with it. It's loaded and racked when the police arrive. And so is the High Point, loaded and racked when the police arrive. So he buys a gun. What does he need a gun for? If he's working a job at Lawrence Tech, why does he need a gun? He's on parole. Why does he need a gun? He needs a gun, ladies and gentlemen, because that's part of the process. So when you ask yourself, who do you believe in terms of credibility, start thinking about what Mr. Williams said and Mr. Adams said about how when he gets out of prison, he starts talking about the ideas of doing these walk-in robberies. How it's easier for them to walk older people into their homes to rob them than it is to break into someone's house. Because they control the situation, and how they can prey on older people because they're more vulnerable and because they're more likely to have money. So what do you need to do that? What's the first thing you need to do that? Well, you need the idea, which he had, according to them, but then you need a weapon. And he tells us he buys his weapon soon after getting out. So why does he need a gun? For protection for himself? To leave in his drawer? No. He needs it to do the walk-in robberies. He also needs help. He also needs compatriots. So he gets back to the neighborhood, he gets back with his friends, and you can see the photograph, and you can see all the exhibits where they are friendly together. They're hanging out together. There's photographs of them hanging out. Why is this important? Because as we're going to learn, a conspiracy is not something that you write down on a contract. A conspiracy is not something that you notarize like you would a car lease or a purchase of a home. A conspiracy is an illegal act. So you're not likely to have notarized documents or signed paperwork. You're going to have actions and words and conduct. And that's what you have. You have associations. So you can look at the associations of the defendant with Mr. Williams and Mr. Russell. You can see how they are associated together, how they hang out together. And you can look at those photographs that he described for us, the defendant. And you can see that he needs help. So he needs guns, he needs ammos, he needs to use those guns and ammos. And you know what? This conspiracy requires sharing back and forth. And it's interesting, and I want you to think about this idea of this sharing back and forth. The defendant denies it. He says, no, I never shared my guns. Those are my guns. But he says that because he knows he has to. Because he knows he has to say he was not on Ward Street because his gun was used to shoot Mr. Cobb. His gun and Alan Corbin's gun were used to shoot Mr. Cobb. And it's interesting because another thing that he says is very interesting is he says that Timothy Russell and Robert Williams aren't friends with Alan Corbin, right? So how does Alan Corbin get the gun that Mr. Williams used to shoot Mr. Cobb? Remember, we'll talk about this in a minute, but Mr. Williams told us that the defendant had his .40, he had a 9mm, and he gave that 9mm to Mr. Corbin. And lo and behold, just recently, within the past month, we confirmed that the gun taken from Alan Corbin was used on Ward Street. So when you're judging credibility about who knows who and who to believe, there's a direct connection to how the defendant lied to you, about how Mr. Williams doesn't know Mr. Corbin, because how does he get his gun? Williams said he gave it to him. And we've proved he gave it to him because the gun that was used on Ward Street was the gun that was taken from Alan Corbin. So when I suggest to you that there's a sharing going on back and forth, there's something else I want to mention to you too, which he doesn't talk about. In his house is a .40 caliber gun and a 9mm gun, but also a box of .380 ammunition. .380. Those don't work, according to the officer, in a 9mm or a .40 caliber. So why does he have a box of .380 ammunition? Why does the defendant own a box of ammunition to guns he doesn't own? Because they share. They share. You also heard that masks and gloves and dark clothes were found at each other's houses. They found surgical masks and surgical gloves. So the evidence, ladies and gentlemen, suggests to you that the defendant lied to you when he said they don't share guns. He lied to you when they said that they're not in the habit of sharing their guns. Let's talk about some of the text messages. Now, the bottom one is interesting because that's on May 17th. May 17th of 2015. From the defendant, it says, grab the mags and the shells. Come on, Bright. The ones from January, bring that mask tomorrow, don't forget, and I'm going to hit a lick for some money. Now, those are identified from Russell's phone as someone named Kev. Okay? Now, the defendant says, that's not me. You never proved I had that number. My parole officer said I didn't have that number. So, like, you didn't catch me, just like you didn't catch a Ruger in my house. So, because I can't prove it, it's not from him. But think about what he's saying, ladies and gentlemen. He told you in his own words that these discussions on text messages are evidence of planning robberies. Bring the mask, bring the guns, gotta get your car. Think about that. He said that from his own words, his own mouth, which suggests to you that he's right. This is evidence that they're planning robberies. This is evidence back and forth that the defendant and Williams and Adams are talking to each other about these kind of robberies. And this is Mr. Russell, who's also part of the conspiracy, as you heard. Talking about hitting the lick, talking about bringing the magazine. Why is he talking to Mr. Smith about get the mags and the shells back in May? This is right around the time that, according to him, people were stealing his guns and taking them and using them for crimes. And he says, I didn't know anything about what they're doing. Why is he telling him to bring the mags? Why is the defendant telling them to bring the shells and come on if they're stealing from him and taking his guns from him? Because he lied to him. He lied to him. From his own text messages, we know he lied about that. Because he talks about preparation and planning in his own text messages. Now, he wants you to believe that there's some other Kev in the world that's friends with Mr. Adams, friends with Mr. Russell, friends with Mr. Williams, and it's not him. It's some other Kev who's planning robberies. Just so happens when he gets his phone in May, he's still talking about mags and shells with the same individuals. And you heard Mr. Adams say, I don't know anybody else in the world named Kev but this man. The judge is going to give the law on what an agreement is, agreement for a conspiracy, but it's my job to show that beyond a reasonable doubt that there was an agreement, that the defendant and someone else came together to an agreement. But it's your job to look at all the circumstances and facts and decide whether you believe there was an agreement to commit robberies. And one of those things you can look at are those text messages, and you can look at all of them. Talking about bring the guns, bring the mags, bring the shells, don't forget the masks. Those discussions that take place between someone named Kev in January and Mr. Williams and Mr. Russell and Don Diego Adams. Talking about maybe we can get little Diego Adams' car. That's circumstantial evidence, ladies and gentlemen, of an agreement between the defendant and the other individuals to have an agreement to commit these crimes. And you may infer from the circumstances that there was in fact an agreement. Membership. I have to prove that he was a member of the conspiracy. And it's also important to understand that I don't have to prove that every single member of the conspiracy was in for the whole conspiracy. Like, for example, Mr. Adams. Mr. Adams said, you know, I only went inside the house one time, and that was on Foul Street, and I saw Mr. Reeser tied up, and I was sickened by it, or upset by it. And he never went into the houses, but he was a getaway driver. And he was also facilitating the person who would go and sell the jewelry and pawn the items at the pawn store. So his role in the conspiracy was sort of lookout and the getaway driver. That's an example of someone who has a membership in the conspiracy, which doesn't have to mean he goes inside and sticks a gun in some old person's head or face and demands their jewelry. He's just as responsible for the conduct. And that's important because once you agree to be a member of the conspiracy, you don't even have to go to the armed robbery. You don't have to have a gun. You don't even have to be involved in the pawning or the selling. All you have to do is have a plan and do something to further the conspiracy. In this case, share guns. In this case, share masks. In this case, share magazines, ammunition, etc., etc. That's how you prove membership, ladies and gentlemen. Now, I don't want to dwell on this, but these are the locations of the robberies that took place in northwest Detroit. And there are a number of them. When you look at this, you see people's homes. Every dot, every star represents a person who had a gun put in their face. Every circle represents someone who was put in fear for their own life. Every circle represents someone who was deprived of their property at gunpoint because of the plan the defendant came up with. We know it started in January, and the first robbery that takes place occurs at the Family Dollar. I'm not going to go over these in detail. Then LaSalle, then Mansfield, then Oak Drive, where Judge Berg was shot. Doesn't stop there, it goes to Gricksdale, Hilldale, Eileen, Asbury Park, Faust, Mr. Rooser, Ward with Mr. Ford, and Mr. Wood, and the Rainbow Jewelry Store in May. So you can see, ladies and gentlemen, that during the course of this time, this 6-month period, when these crimes were being committed, they were far-reaching. They were far-reaching crimes. I talked to you a moment ago about credibility. And I want you to start thinking about credibility. And one of the things I said in my opening statement was, you have to judge credibility of the witnesses. That's your job. And the judge is going to give you a guideline, a map. And one of the things he's going to tell you is that you have to decide who to believe and not to believe. And he's going to tell you that when you consider the testimony of cooperating witnesses, people like Adams and Mr. Adams and Mr. Williams, you have to consider that very carefully, because they may have a motivation to testify. They may have a motivation. They're getting a benefit. And you heard the benefit. They both pled guilty, one to home invasion, one to armed robbery. They're going to prison for 5 to 20 or 5 to 15 years, and they have to tell us about the crimes that they were involved in with themselves and with the defendants. But I want you to pay particularly close attention to this fact. It's important that you see how the testimony of the witness gives you, how it fits the other physical evidence in the case, how what they say fits the physical evidence in the case when you're judging credibility. Let's talk about Oak Drive. Now, you heard testimony from Mr. Williams, you heard testimony from Mr. Adams, and they indicated that they were together, 4 of them. Adams, Williams, the defendant, and Mr. Russell. And they were out looking for people to rob that night. They were driving around looking for someone to rob. And Mr. Williams and Mr. Adams both tell you that they see the victim, a white male, a little older, outside talking to someone in a vehicle. Now, Mr. Williams says it's a minivan. Mr. Adams says, I think it's an SUV, I can't be sure. But it's on the side street, and we see him. And he draws our attention. He's out of his house. He's talking to someone. He's distracted. And then he starts to take in his trash cans. He pulls in his trash cans as he's moving along. He starts to take in his trash cans. And that's when we pulled the car around. Then he says, they got in the car. I stood in the tree, Mr. Williams. The defendant went up to him on the porch and shot him. They wouldn't let us in, and he shot him. And as they're leaving, the words from the Mrs. Sevier come out, and they come out as motherfuckers as they're running away. Now, those are all independent facts that both Mr. Williams and Mr. Adams told us about. And I would submit to you that those facts are corroborated because we heard not only from them, Adams and Williams, but we heard from Judge Berg as well. And we also heard from Ms. Sevier, too, about how the victim in this case, Mr. Berg, Judge Berg, walked her friend to the car, and how, in fact, he was taking his trash cans in, and she comes out, and what does she say? Motherfuckers. How does Adams and Williams know that, if they weren't there? And so your job, ladies and gentlemen, is to decide whether you believe their testimony, whether you can independently verify what they say when they say these types of details about crimes, whether you believe him when they say that the defendant is involved in a conspiracy. The defendant is one with him. So I tell you, this is circumstantial evidence. This is direct evidence, circumstantial evidence that they're telling you the truth. Because how would they know those details if they weren't there? How would they know those things happened? Another thing that corroborates them is what Adams tells us. Remember Adams, he says, we're all together, we're in the car, their positions may be different, and Adams thought maybe the defendant had a .38. He didn't know if Mr. Williams had a gun or not. But I suggest to you that's actually boosts their credibility. Because then they came in with the exact same story and said, I had a .45, he had a .38, they got out of this door and that door and ran 32 degrees to the left versus 32 degrees to the right. That would be rehearsed. But their recollection is somewhat different about who had a gun and who was sitting in what position in what car. And that corroborates their credibility because no one remembers every single detail the same way. If they did, they'd be suspect. But in this case, in addition to what he tells us about, Mr. Adams tells us about being in location, we know independently from Stan Brew that in fact that's true. Because Stan Brew told us that his phone calls, Mr. Adams, he starts a phone call, I don't know, 15 minutes or so before the crime takes place. I can't remember the exact time. But he's in this sector here, to the east, no, to the west of the area where the judge was shot, of Oak Drive. He starts a call here, and the call is traveling in an easterly direction. And he ends the call just moments before the shooting takes place, and he's in the vicinity, the tower vicinity, that was covered by the tower vicinity for the victim's home, in this case. So when Mr. Adams says he was driving the car that night, it's independently corroborated by his testimony. Now you've heard some discussion about how, in fact, they changed their testimony. First, Mr. Adams said, I wasn't there. I heard about it. But then he comes forward and says, you know what, I have to be completely honest, I was there. I was driving the car. And you heard Mr. Williams say, the first time he told this version of events, he said he didn't get out of the car, that it was Russell and Smith that got out of the car. And then he comes forward and says, you know, I want to be completely honest with you. I want to tell you what I did. And what I did was I got out of the car and I stood by the tree. Now, it's your job to decide whether you believe that. But think about this. Why would he put himself more in harm's way? Why would he put himself more involved if he wasn't? If he was lying, wouldn't it be easier to say, I didn't get out of the car? He came forward and said, I actually got out of the car. I just didn't want to be involved with that. But he made that admission. Does that help his credibility? I would suggest it does. That's sincerity, ladies and gentlemen. That's him coming forward. But he came forward on his own. You heard the testimony about how he came forward and how he made those statements on his own. So when you judge credibility of Mr. Williams, think about how he corrected his testimony. And think about how that correction of his testimony goes a long way to whether, in fact, you believe what it is that he says. Now, in addition to the cell phones, we also heard that Mr. Adams said he dropped him off at Alan Corbin's house. And recall the testimony of Stan Brew. There's no cell phone activity on the defendant's phone for several hours before the shooting takes place. The first connected call takes place 37, 38 minutes later in the vicinity that is identified as Alan Corbin's house, which is here. Not too far from the scene of the crime was. And you heard him say how he took him home, dropped him off. And you heard the defendant say how he was staying there from time to time. And the first call, I think, is at about 10 minutes to 10 or so, thereabouts. And it places him in the vicinity of Alan Corbin's house. Right where the defendant said he was staying from time to time in that area. Right is what Mr. Adams told us. So the cell phone records corroborate not only what Mr. Adams tells us about himself, but also what Mr. Adams tells us about the crime itself. So, ladies and gentlemen, Oak Drive is part of the conspiracy. Oak Drive, because they were looking for someone to rob. And in the course of the robbery, Judge Berg got shot. Now, when you think about credibility about Mr. Williams, I want to emphasize this. There are things that Williams told the police that they had no idea about. They had no idea some of the details that he came up with and some of the facts that he told them about his involvement in the crime. First thing he talked about was the jewelry store robbery. He told us about the jewelry store robbery. Didn't know anything about it until he stepped forward and said, we robbed a jewelry store a few days ago before he got arrested in Roseville. He's the one who told us about that. No one knew anything about that. He tells us it was part of the conspiracy. He tells us they were acting in concert together. He tells us it was his idea. And so does Mr. Adams. Adams says it was Williams' idea to do a robbery of a jewelry store. He talked about how they wore clothes to pretend to be customers, how they acted to be concerned citizens, and how they pawned the items the next day. Think about this, ladies and gentlemen. The defendant says he did this on his own. That he had all this was on his own accord. But think about some of the things that we know about. We know that Williams told us about it, and Adams told us about it. But we also know that the cell records put him there. We also know the surveillance cameras put the defendant there. The fingerprints put them there. And Smith puts them there. But Smith says he acted alone. Smith says that Williams and Adams weren't there. But what Smith doesn't know, the defendant doesn't know, is what the victims told us. The victims, the person who got pistol whipped by the defendant, the person whose blood you saw on the floor of his own shop, he was hit so hard with that gun because he dared to run away or he dared to push an alarm, the blood on the floor that he inflicted, that person corroborates what Williams and Adams says. Because what does he tell us? He says that the victim goes outside and two young African-American men come up to him and say, what happened? And he tells them he was robbed by those individuals. And then smart thinking Williams and Adams says, I'm going to go after him. And they go off. And what does Williams tell us about him? He says the guy was bleeding from his head. Now, the defendant says he wasn't there. I told him about this robbery, and the only reason he talked about it because he got a good deal in his testimony. But he left. The defendant was gone. He booked out of there. How does he know? The victim, the owner of that shop, goes outside. How does he know that he's approached by two individuals? And how does he know he sees the blood in his head? Because that's what happened. So when he says to you that Williams and Adams weren't there, he's lying to you. Because they told you he saw the victim. They told you he saw the blood in his head. It's a very important distinction that establishes the fact that he was there and they lied. Also, he admitted the robbery. But he can't say it's part of the plan because that's what the conspiracy is about. So he said, oh, I was just driving around, did my own thing, did my own robbery. But does that make sense, ladies and gentlemen? We'll talk more about that in a little bit. But he says, I don't carry my guns with me. I happened to be at my friend's house, staying at my friend's house in Warren, and Roseville's right down the street from Warren, and we're driving down the street past it and decided to do a quickie robbery. But he never carried his guns with him, he said. Remember that? Unless he needed to. This was part of the plan. So again, he lies to you about that. He lies to you about the fact that this wasn't part of the conspiracy. Because it is, ladies and gentlemen. And you can look at the photographs. You can see him going. You can look at the cell phone records. You can see that puts him in the scene of the crime. Look at his fingerprints. You can look at all the things that we talked about, how this all unfolded in the videos, and how his palm prints matched. But most importantly, remember what the victims told us about how he saw those individuals. And Adams told us that he didn't go with them, but it was part of the pawn with Corbin that very same day. Now think about this too. The very same day, the defendant and Corbin go and pawn those items. And where do they go? You can look at the pawn slip. They go to Michigan Cash for Gold. One of the very same pawn places that they've used throughout the course of this conspiracy. Time and time and time again. And this is an exhibit. You can look at it. It's dated the same day as the jewelry store robbery. The time's on here somewhere. Yeah, right here. Time is 2 o'clock in the afternoon, 2:15. Alan Corbin, $2,300 worth of merchandise. Is it a coincidence that Alan Corbin, who doesn't know Williams, according to Smith's testimony, doesn't know Russell, doesn't know Adams, they go to the same place that Denisier went to, that Alan Corbin went to, time and time and time again during the course of their conspiracy? It isn't a coincidence, ladies and gentlemen. It's part of the process. The jewelry store robbery is part of the conspiracy. But Williams doesn't stop there. Williams tells us more. He told us about a shooting on Ward Street. And that took place, I think, May 16th, thereabout, 2015. This shooting where an individual inside of the Dodge Durango, they try to rob him. Now, he says that there are 3 people. Tuan is there. Williams says he's there. And the defendant says he's not there. But Williams says the defendant is there. And the truck tries to pull away, tries to get away before the robbery. The victim says he knows what time it is. He knows what's happening. I think his name is Mr. Ford. He knows what's happening on this particular robbery. And Williams tells us he's with him. He uses his .40 caliber, and he uses his 9mm handgun that was later turned over to Alan Corbin. In addition to the lab reports, ladies and gentlemen, the lab reports that prove that the defendant's gun was at Ward Street on that time, and the gun that was taken from Alan Corbin was the 9mm that was used. The one thing he forgot about when he said he wasn't there was his cell phone. Remember, he got a new cell phone on May 8th, about 4 o'clock in the afternoon. We'll talk about that in a minute. May 8th, he gets a new cell phone. May 16th, his cell phone, seconds before the robbery takes place, at 3 o'clock in the morning, places him in the tower designated with Ward Street. Here's Ward Street right here, right where the scene took place. The defendant's phone is right there on Ward Street, right at the scene of the crime. He told you today he wasn't there. He was nowhere near there at that time. And that Mr. Williams is lying. That he stole his gun. That he came and got it and took it back. But I guess he stole the cell phone too, didn't he? Because the defendant's gun and his cell phone are there. He wants you to believe he's not there. Because his cell phone records prove that he's there. His gun proves that he's there. So when he says he wasn't, he's lying to you. Lab reports, you can look at those. And the timing of the lab reports is very important. I want to just talk to you about that for a second. When the guns are first confiscated back in May of 2015, they're taken to the lab, they're examined, and yeah, they work. They send them back to Detroit Police Department. Then, when we find out, Mr. Williams tells us about the Ward shooting, and he comes forward to the officers, and you heard him testify, he thought he killed someone. He's like, I got to tell you about this. He tells them about the shooting on Ward, and he tells them about the guns that were used. Then they take the guns that were recovered, the .40 caliber and the 9mm taken from the defendant's house, they take them to the lab, boom, the .40 caliber hits, but the 9mm is excluded. The defendant says, I gave the 9mm to Alan Corbin. So then they go and find Alan Corbin was arrested. You heard the officer testify. He was arrested, and he threw the 9mm in a bag of then with potato chips, and they got that gun, took it to the lab, and it matched. So when Williams tells us that the gun that he used with the defendant on Ward Street, it's proved by the lab sheets. But the timing is important, because we did not know that until after Williams agreed to testify, and after Williams told the police about how he and the defendant used their guns. Again, not only do we know that his gun was used, but we know that it's his gun because if you look at his cell phone records, there he is with the gun, with the laser sight. And remember what the victim told us, Mr. Ford told us when he testified. He told us about how he was sitting there and the first thing he saw was a laser. First thing he saw, and he knew what time it was. The guy starts the truck and they drove away. That laser, ladies and gentlemen, the one the defendant had, the one that was in his house, the one that he used, just like Mr. Williams said he did. The Ward shooting is part of this conspiracy because they acted together to try to rob someone. So, there's a third story. There's a third that we didn't know about. The Family Dollar. Mr. Williams says, we robbed a Family Dollar in January. Well, one of the first things we did was rob a Family Dollar in January. And he says he and the defendant go inside there to rob. They get money from the register, and you heard the victim come in and testify that they were together. There was a tall guy that went to the cash register and a smaller guy who was looking near the door, like skulking near the door, trying to hide himself. The customer wouldn't give his wallet. Mr. McCoy says the gun was shot, pointed down, and it shot. He wouldn't give him his wallet. We didn't know anything about this, ladies and gentlemen, until Mr. Williams told us about it. But there's another one that we didn't know anything about, and that's Asbury Park. You heard Mr. Williams come forward and say, in addition to the jewelry store in Ward Street and Family Dollar robbery, we did one other thing. We robbed a female and a male who were sitting off the street on May 8th, early morning hours, just after midnight, on May 8th, 2015. The car was parked on St. Mary's, and we took a Rolex watch, we took a jewelry from the man, took Cartier glasses, and he also said something else. He said there was a woman that got away, and Mr. Williams said that the defendant ran after her, brought her back, pistol whipped her, ordered the guy out of the car, took the car, and they left. And we also know this is true because Mr. Adams tells us that the early morning hours of that day, May 8th, the defendant calls him and says, hey, you want to make some money? I want to take you, I want to go sell some jewelry. And so, he gets a phone on May 8th. You can look at that. He activates his phone, a brand new phone on May 8th. And he sends a text in the afternoon saying, hey, I'm about to get a crib. All of a sudden, he's flush with money. Because what Adams told us is that after they robbed the individual, Mr. Cobb, they went to the jewelry, they went to the pawn's apartment, and they pawned those items. And look at the time. May 8th. Early morning hours. 9:30 or so. When Mr. Adams goes and pawns those items. And he told us it was a Rolex watch. And he told us he got a pair of Cartier glasses and some jewelry. He got $5,000. Now, is it a coincidence that on the day, the very day, that Mr. Williams says that he and the defendant robbed Mr. Cobb on Asbury Park and got $5,000, that the defendant gets a new phone? The defendant says, I'm going to get a new crib, because now he has money. He told you he needed money, he didn't have a job, now he's got some. But he tells you $5,000 isn't an awful lot of money. And yet he gets a new phone. And yet he says he's going to go and get a new crib. Also, keep in mind the fact that this is independent corroboration of Mr. Adams' testimony. Because Adams says, I took him to Ziedman's. He negotiated for me, but I signed the card. He gave me the Cartier glasses, and you can look at the receipts, because later on there's a pawn for Cartier glasses where Adams gets $400 or something from the Cartier glasses and gets them back and has them fixed. You can look at those if you want later on down the road, because they corroborate what Adams tells us. Why would they give the defendant $5,000 if he wasn't involved? So again, Asbury Park is part of the conspiracy. These are 4 cases that we knew nothing about until Williams told us. And every single case was corroborated by what he told us about how the robberies occurred and how it was there. You should believe him when he says that the defendant was there, because we didn't know anything about them. There are more robberies. And I want to emphasize one thing that's important, that in these instances, the Family Dollar, Oak Drive, Asbury Park, Ward Street, and a jewelry store. One thing that happened during the course of these robberies is that the victims didn't comply. Family Dollar, the very first one, the victim was shot. The gun was discharged because he wouldn't comply. Oak Drive, less than 2 months later, the victim is shot, Judge Byrd, when he doesn't comply. Asbury Park, in May, the victim is pistol whipped when she tries to get away. Ward Street, 21 shots are fired during the course of that robbery because the victim tried to get away. A few days later, at the jewelry store, the defendant pistol whips the jewelry store owner because he ran from him and tried to pushed aside on the line. He didn't comply. You heard Mr. Williams tell us that if people complied, they weren't hurt. But if they didn't comply, they got hurt. That was part of this conspiracy. If you don't comply, you get hurt. If you comply and you do as we say, when I put a gun in your head, you won't get hurt. There are 5 incidents, ladies and gentlemen, during the course of this conspiracy where people got hurt because they didn't comply with the demands of the defendant, or the demands of Mr. Williams, or the demands of Mr. Russell and Adams. I also want to emphasize this. Remember, the Ward Street shooting, Williams said he shot first. He fired the first shot, not the defendant. He fired the first shot. There are other robberies that we talked about. We talked about the Hilldale address when the Stewarts were robbed on April 15th. 3 people come up to them, a tall guy, 2 other guys. The tall guy is the leader, according to Mr. Stewart, puts a gun in his head as he's getting out of his car, and he says, "I know what this is." And they walk him in and rob him. We know that that's right down the street from the defendant's house. We know that we heard testimony from Mr. Adams and also from Mr. Williams about how they planned the robberies and watched people to see if, in fact, they had something they wanted to rob. You heard Mr. Stewart say he was driving, I'm sorry, I'm not a car guy, it was a retirement Cadillac, and it sounded like a really nice car. I'm sure it was expensive. And I'm sure that's what drew the attention of the defendants, because they were watching the house. Mr. Adams gets a call when he's somewhere else and says, "Come back, because the guy just left, and we're going to watch." And they're waiting. They're lying in wait, waiting for Mr. Stewart to come back so they can rob him, waiting to get a chance to go inside that house because he had a nice car. Now, Mr. Stewart tells us that 3 people robbed him that day, the 3 people, as part of that conspiracy. Now, in court on Thursday, the defendant said, "You know, I used those credit cards. I was on the street, I was walking around, I get a credit card, and I decided to use it. And silly me, I went and used the credit card and got caught. But I had nothing to do with the robbery." You heard Mr. Stewart testify that, in fact, the tall guy is the one who was the leader. And you heard the defendant say he's taller than everyone else that's involved in the conspiracy. But he says, "I didn't do it. I wasn't involved in the robbery." He raised his right hand and took an oath that said he wasn't involved in the robbery. He said that he was not involved in that particular robbery at that time. But that's not what he told this court back in November of last year. Back in November last year, he testified under oath that he robbed the Stewarts. Now, the reason why he had to get in the stand and lie, because if you read the transcript, it says he and some others were involved in a robbery. So what that means is that this transcript is testimony under oath that proves the defendant is part of a conspiracy. It proves that he and others were actively involved in robbing people. So when he testified under oath in November, he said, "Yeah, I did it." He admitted it. But now that he's charged with conspiracy, he says, "Oh no, I didn't do that. I had nothing to do with that. It wasn't me. I wasn't there." So think about that, ladies and gentlemen, when you're talking about credibility. When you compare the credibility of Mr. Williams and Mr. Adams to the defendant, someone who lied under oath versus someone who told you about 4 crimes that they committed together that he didn't have to tell you about. It's a big difference when you're judging credibility. Talk about Mansfield. Now I'm going to go through these quickly because you heard the testimony about the people that came in, how they were robbed. But the ones I want to highlight are the ones that are part of the conspiracy where they take items and they go and use the victim's ATM right away. And you can look at the bank records, you can look at the exhibits, you can look at the videos if you want, you can see the individuals. Now Mr. Williams tells us this is Timothy Russell. And there's a photograph that I skipped over you can look at of the defendant wearing that Nike black hooded sweatshirt. And this defendant, Mr. Russell, who's not part of this case, but he's wearing that polo shirt. There it is. Right there. There's Mr. Smith wearing the Nike, and there's Mr. Russell wearing the same one that's used, as you can see on the monitor, using the victim's credit card from Mansfield. Another robbery takes place on Fowl Street. Now this is interesting because in this one, both Mr. Williams and Mr. Adams tells you that the defendant wasn't there. He was part of this one. We went without him on this one. And you can see the video surveillance of Timothy Russell's shirt and how distinctive it is, and how he used that shirt to withdraw that money, and how it was on his Facebook page. And that was part of the puzzle, as the officers told you, to unraveling this conspiracy, identifying the perpetrators involved. Not only did Mr. Smith call his parole officer and say, if someone says I'm doing robberies, they're lying, don't believe them. Check. Then they find out that he used Timothy Russell's name when he's arrested. Check. They pull Timothy Russell's Facebook page, and it matches the video of the person using the stolen credit cards from Mansfield Street, from Bow Street, right on the video. And then when they do a search warrant, a little time later, there's the same shirt. That's his friend. That's the friend that he uses his name when he gets arrested. He told you last week he would use his name, Mr. Russell, to get out of a parking ticket. He would lie to the police to get out of a parking ticket. We know he lies under oath. We know he lies to the police to get out of a parking ticket. Ask yourselves, how much would he lie to get out of shooting a judge, or robbing an old lady, or pistol whipping someone in a jewelry store? Pawn slip from back in May. Mr. Rooster said they took his television. Don Diego Adams said that he went inside, got the television, put it in the trunk of his car. You can see where it used to sit in his house, and now they sold it at Zedman's. About $150 for it. That's what Adams tells us. Don Diego Adams' signature is right there. Now, in order to prove conspiracy, I have to prove the elements of the crime beyond a reasonable doubt. And the elements of a crime for conspiracy beyond a reasonable doubt are basically simple. The defendant and someone else agreed to commit an armed robbery. He specifically intended to help someone commit an armed robbery, and that the agreement took place between the periods of January and May of 2015. You've heard ample testimony, ladies and gentlemen, not only of the agreement between the defendant and Mr. Williams and Mr. Adams and Mr. Russell. You've also heard from the victims themselves, time and time again, about how they were in their home, they were robbed of their possessions, and the gun was pointed to their head, how their ATM card were used, how things were pawned. And you saw the pawn slips over and over and over again from Mr. Adams about how he went and pawned these items. So in order to have a conspiracy, all it is an agreement to commit a crime. That's all it is. It's simple. We agree to commit a crime. And what evidence that we agreed to commit a crime? Well, Williams told us that. But then we have example after example after example of those crimes. And we have the defendant under oath admitting that he committed those crimes back in November. That's all you need for conspiracy. His plea under oath is evidence that he is guilty of a conspiracy. Because he said those words under oath. That's all you need to convict him of conspiracy, ladies and gentlemen. That plea alone. Armed robbery. You've heard, and of course the judge will tell you, that armed robbery means that you have a weapon, that you use a weapon for force or violence against someone else, armed with that weapon, in the course of committing a larceny. In this case, the course of committing a larceny was the plan to rob Judge Bergen's family. They were going to go rob him just like they robbed on Mansfield, just like they robbed on Hillsdale, just like they robbed on Griggsdale, just like they robbed over and over and over again, to walk him in and to rob him. So during the course of that robbery is when he got shot. So he's guilty of armed robbery, because the armed robbery element says you don't have to commit the armed robbery. You don't have to commit a lot. You don't have to get anything, as long as you are in the course of committing a robbery. If you do something in the course of that to commit a robbery. In this instance, they got out of the car, they walked up, they asked to go in the house, they produced a gun, and the plan was to go inside, secure the house, and then Mr. Russell or Mr. Adams are going to come in and help facilitate the robbery. So, ladies and gentlemen, he's guilty of armed robbery. Assault with intent to do great bodily harm. Now, he's charged with assault with intent to murder, Judge Bergen. The judge is also going to instruct you on assault with intent to do great bodily harm. And that means that you defendant physically injured another person. You had the ability to physically to injure someone, and then you caused great bodily harm. All that means is that you wanted to hurt someone, and you caused injury. The defendant is guilty of assault with intent to do great bodily harm. But you know what? He's guilty of more. He's also charged with assault with intent to commit murder. And the judge is going to tell you 3 elements. The defendant physically injured another person, had the ability to cause the injury, and he intended to kill. Now, the judge was shot in the leg, right? And so, you can't intend someone to kill someone and shoot him in the leg, right? The defendant's own words on Thursday told you. If you point a gun at someone and pull the trigger, you know a person could die from their injuries. It doesn't matter what you hit. The gun is a dangerous, dangerous object. It's loaded. It doesn't matter if you shoot someone in the foot, the finger, or in the head. If you point a gun at someone from 2 to 3 feet and pull the trigger, there is no other intent but to kill someone. And the defendant says he knew that someone could die if you shot him. There are other charges too. 2 other charges: being a felon in possession of a firearm and possessing a firearm with the commission of a felony. We know those cases. We know those counts because the defendant, by his own admissions, is a felon. The defendant, by his own admissions, knows he can't possess a firearm at all, but he does. So he admitted to that. And felony firearm means just possessing a firearm during the commission of a felony. He's guilty of that too, because he said he can't have a gun, and yet he had a gun. So he possessed a firearm during the commission of a felony. Ladies and gentlemen, the evidence shows, beyond a reasonable doubt, that the defendant is guilty of these crimes. The evidence has proven that, in fact, he and his friends, Mr. Russell, Mr. Williams, Mr. Adams, conspired to rob him. And it's proved by the testimony of the witnesses who came in and the testimony of the physical evidence, the text messages, the guns that were recovered, the masks that were recovered, the clothing that was recovered, the casings that were recovered, the shells that were recovered. All those items point to one thing, that the defendant was part of this conspiracy. And when you judge the credibility of the witnesses, I submit to you that the testimony of Mr. Williams, Mr. Adams, as well as the victims in the case, is credible. For those reasons, the defendant is guilty. Thank you.
Thank you, Mr. Moran. Ladies and gentlemen, we're going to take 10 minutes, step into the jury room, if you would, please.
All rise. You may be seated. Yeah, I figured. I know.